Good day, Crime Talk aficionados. We have another great show for you today. First, more secrets in the Bryan Kohberger case. Karen Reed, the stage is set for trial. Round 2 begins next Tuesday. An update on the Lori Vallow trial. The interview tapes have been released in the Delphi homicide case. I'll be honest with you. I have no sympathy for Mr. Allen being so dumb. Luigi Mangoine is heading to court Friday, but we won't get to see him because, well, he's going to federal court. And I know you can rest assured now that Karmelo Anthony has made his way home safely to their new $900,000 home in the gated community for his safety. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we get to the day's docket, please go to crimetalksearch.com. Sign up for that background subscription service today. You know you want to. You know you need to. Go to crimetalksearch.com because when you do, you can sign up for a background subscription service and do as many background searches as your heart desires on anyone, ladies and gentlemen. And you get the report literally prepared while you wait and emailed a copy to you. And on top of that, if there's updates that come along, you can be told and advised of that so you can get that update. You're going to get all types of information on the individual you're searching. Cell phone numbers, email addresses, social media presence, whether they have a criminal history, whether they have a spouse, whether they're divorced, whether they have liens or judgments, criminal history, and whether they have to put themselves on one of those, registries you hear so much about. That's right. Go check them out. Particularly, ladies and gentlemen, if you have children and you are bringing new people into your life, go check them out. You're going to be happy that you did. CrimeTalkSearch.com. All right, let's go ahead and open the record for April 16th, the day after tax day. Ladies and gentlemen, I hope you made it. Hopefully you found out if you're getting, if you're got a refund, that means you overpaid the government. You gave them an interest-free loan. And if you didn't, you had to write a check. Or you could file an extension, but you still had to write a check. I hate April 15th and October 15th, whatever the day is for the extensions as well. Anyway, I hope you all made it through it. All right, let's get to the news. First, more secrets in the Bryan Kohberger matter. All right, let's talk about this. Some couple of new filings, and of course, everything has to be secret, right? I know that's the way it's done in Idaho. Anyway, there is a stipulated motion to seal the defendant's response to the state's first supplemental discovery request. Okay, fine. Then we got the order. Sealing defendant's response to the state's first supplemental discovery request. But then we have the defendant's response to state's first supplemental request for discovery. Transfer of test materials. Now, what does this mean, ladies and gentlemen? Well, let's read on. Comes now Bryan Kohberger by and through his attorneys of record and hereby submits their response to the state's first supplemental request for discovery as required. Mr. Kohberger first responds that he has complied with discovery requests for experts as provided in the Idaho criminal rules. This specific request for additional material related to Idaho Criminal Rule 16C came for the first time on April 2nd. Mr. Kohberger responds specifically to Part 2 of the state's request. Upon agreement from the Latah County Prosecuting Attorney's Office, the requested test materials will be provided between the doctors directly. Dr. Orr will provide testing data to the state's expert, whose name is redacted, who is a licensed psychologist. This method of disclosure is in compliance with the APA Ethics Code Standards 9.04 and 911. Dr. Orr must adhere to these ethical standards in releasing test materials, including protocols, test items, etc., and Dr. Orr will work directly with, name redacted, to transfer the requested materials once the contact information has been exchanged. Signed, Ann Taylor. So there you go, ladies and gentlemen. The state is saying, hey, I appreciate your report that you sent over from your expert about Mr. Kohberger and all of his ailments and all of his inabilities to do anything and assist and, autism and blah, 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 blah. All of that stuff. And the state's saying, hey, that's really great, but I'd like to see the actual underlying data, so to speak, as it relates to, so we can look at the opinions to see if you took any artistic license with the opinions or if they conform to the American Psychological Association standards and various other DSM type of things that the defense will be using if the matter gets to the mitigation stage. Now, I would just say, now I understand it's the underlying material, but I think if those test results really came out in favor of my client, I would be attaching those to every filing I could make if it was good. I remember once I was a law clerk and there was this case going on, and literally they had the smoking gun memo of this conspiracy. It was a big business case, and they attached that memo to every court pleading that they had just to show the world, look how, unsympathetic the other side's party are going to be. And that's similar to what I would do if I had a good document for Bryan Kohberger. I wouldn't be running around in secret. I'd be saying, here are the reports finding that he has all these ailments. Oh my gosh, feel so sorry for him. Oh my gosh, it's sad, pathetic. Please don't put my client to death. But they run around in this secrecy stage, and then all this anticipation builds that there's going to be some smoking gun for the defense to help them out, and it just doesn't turn out that way. I don't know. Ladies and gentlemen, the practice of law has changed a lot over the years, and I'm telling you, I was covering a case for an attorney here in the office, an associate that was handling a case, and it was in juvenile court. And I try to avoid juvenile court. I know this is on a tangent, but I'm going to talk about it anyway. Juvenile court, ladies and gentlemen, what an absolute waste of resources. And this is why I knew why I didn't like to go there. But I was like, no, I'm there. I'll take care of it. We're just going to get a resetting. All right. And I'm sitting there watching all these cases. And, the juvenile has criminal cases. They've got two prosecutors sitting there. They've got someone from pretrial services. They got someone from probation. Then they got the defense attorney. They've got a guardian ad litem. They got counsel for a respondent parent. They got the county attorneys. By the count of it, I think there were probably just anywhere between 4 to 7 attorneys on any given case. And everybody was acting like where these kids would do near compliance, that this was somehow great. Like, oh my God, he had hot UAs, but we're going to work on getting those levels down. Well, how about don't do drugs? They're illegal. You're a juvenile. Don't do drugs. But they're like, well, he's doing it, but we're going to work on getting those levels down. He's not doing great in school, but we're going to work on that. How about, your job as a youngster is to go to school, and you're going to behave yourself, and you're going to follow the rules in school, and you're going to get it done. And if not, we're going to send you off to, boys' home or something like that, that they used to. I don't know, ladies and gentlemen. And maybe this is just me. I feel like the work of being an attorney is turning more into being a social worker and, having all these experts to talk about how bad, what? I'm just an old school attorney. You hire me because we're going to go try the case. That's what I want to go do. And I get it. You got to do that. That's part of the job. But my gosh, it just seems like that's all we're doing these days is running around being social workers. Well, I didn't sign up to be a social worker. I'm a litigator, a trial attorney. Hire me when you want to go try the case. You want to do mitigation, we'll have somebody else that can help you out. I mean, I know it's part of the job, but like I said, man, I'm turning into that grumpy old man. I just want to try cases. If you want a social worker, you need treatment for this, treatment for that. I get it. I'm here to try cases. Anyway, maybe you guys can come along and be my co-counsel sometime. That's all we have on the Bryan Kohberger matter. Sorry for that little tangent. I don't know why, but hey, it's my show. I can talk about whatever I want, I guess. Next, the Karen Read case. That's right. A final motions hearing was held today in the Karen Read trial as the attorneys and the judge sorted out remaining issues before the opening statements that are scheduled to begin on next Tuesday. Now, during the hearing, the judge and the prosecution agreed that Aiden Turtleboy Kearney won't be called as a witness because he would have to invoke his Fifth Amendment right to remain silent. I get it. He's got a case pending. Any attorney worth his salt is going to tell him not to testify. I get that. That's a good thing. At least he's smart enough. We'll talk about somebody that wasn't so smart enough down the road. So it took 10 days on jury selection. The jury finally got to 18 people, and the jury consists of 9 women and 9 men, 12 of whom will decide Miss Reed's fate. Actually, not really decide her fate, but decide a question of fact, whether she killed John O'Keefe or not. And, like I said, it was a hung jury in the first trial, so we'll have to wait and see. Anyway, once the jury was finalized, the judge gave the attorneys from both sides the option to hold an opening statement this Friday or to wait until after the holiday weekend. Anyway, both sides agreed to start the trial on Tuesday, April 22nd, as the courts are closed on Monday for Patriots Day. Will somebody let me know if that must be a holiday for just Massachusetts? I mean, I like it. I like the name of it, right? I mean, is this like sports teams, or is this like their founding fathers, the Revolutionary guys? I mean, I don't know, but anyway, it's all good. Anyway, the judge heard arguments from Mr. Brennan and Timothy Bradel, the attorney for Aidan Kearney, who writes a blog under the name Turtle Boy. Now, Kearney is facing witness intimidation charges over alleged behavior towards people involved in the Karen Reed trial. Prosecutors have sought to use communications between Miss Karen Reed and Mr. Kearney that they show her consciousness of guilt. Now, Kearney was included on the prosecution's witness list, so he was ordered to be sequestered during the trial. He previously filed a motion asking to be exempt from the sequestration order so that he can cover the trial as a member of the press. The judge asked Mr. Brennan if he planned to call Mr. Kearney as part of the case in chief, and Mr. Brennan said he did not know, and it would depend on developments in the trial. Now, Bradel, the attorney for Turtle Boy, said that if Kearney was called, he intended to exercise his Fifth Amendment rights, and Brennan said that if Kearney was planning to plead the Fifth, there would be no reason to call him as a witness, unless, of course, you wanted to offer him immunity so that he could testify. And none of that he testifies to at the Karen Reed trial could be used against him in his trial on the other charges. Anyway, the attorney for Turtle Boy offered to exercise Kearney's Fifth Amendment right on behalf of his client ahead of trial, but Brennan said no. He wanted Kearney to do it himself. I like that. After a brief recess to discuss the issue with the attorneys, Kearney returned to the courtroom and met with the judge at a sidebar along with his attorney. Following the sidebar, the judge ruled that she did, in Reed's case, first trial, that Kearney must leave the courtroom when any witness he is charged with intimidating takes the stand. The judge also agreed, as did the prosecution, that Kearney, Turtle Boy, would have a valid argument as to why he would have to invoke his Fifth Amendment rights against self-incrimination. What that means is the judge says, yeah, I believe if you were to testify, you would be incriminating yourself. You would be admitting the elements of a crime on the witness stand. So, Turtle Boy, you have the right to be here, or to assert your Fifth Amendment right against self-incrimination. At least he was smart enough to do that. So once that issue was resolved, then the topic of expert crash reconstruction witnesses from ARCO came up. And as you remember, ARCA testified during Reed's first trial, and the ARCA witnesses are Daniel Wolf and Andrew Rentschler. Both were hired by the federal government as part of the now closed federal investigation into the handling of the case, where no charges were filed. Both witnesses testified that O'Keefe's injuries were not consistent with being hit by a car. Now, the judge admonished the defense attorneys Alan Jackson during a March pretrial hearing for repeated misrepresentations regarding the defense's relationship with the two experts. Now, the defense has tried to portray these two people from ARCA as neutral witnesses who they say had little contact with, but the special prosecutor, Mr. Brennan, said the court obtained a bill from the ARCA group to the defense for nearly $24,000. Brennan then added in the March hearing that there are emails between Reed's team and the experts, with Wolf writing in one email, "If you don't want me to say this, that's fine." Hardly neutral. Anyway, though the judge scolded Jackson and the defense team at the time, she denied the prosecution's request to exclude the ARCA witnesses from the second trial. Anyway, Brennan sought additional discovery, including communications between Reed's attorney and the witnesses, as well as the full billing information and more testing documents. My tolerance about this ongoing development of discovery is an extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent it, Mr. Brennan told the court. The number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is, Jackson responded. Brennan said he requested that the judge allow the ARCA witnesses to testify, but to make sure that they are confined to their initial report from the first trial. Jackson accused them of feigning indignation and said, there's not an ambush here. Anyway, the judge did not make any rulings on the ARCA witnesses. Now, what should have taken place, ladies and gentlemen, is yes, the experts are confined to what they put in their reports, right? This is it. They can't have, expert creep where they get to ask all sorts of other questions that come up during the trial. That's not fair. And so if the opinions are going to change, then they needed to file a supplemental expert report. That's all Mr. Brennan is asking for. And the defense would be doing the exact same thing as well for the prosecution's witnesses. If you have a solid witness, you have a solid expert, man, like I said, you throw that stuff out there, you throw it out early and often, you let the world know what they're going to say. I'm not a big fan of secrecy like that. Anyway, particularly in litigation, you're going to get it. Let's go do this thing. Anyway, there was also a little bit of a hearing as it related to the motion to exclude dog bite testimony. Mr. Brennan argued a previously filed motion during the hearing this morning in an effort to exclude anticipated testimony from Garrett Wing about injuries to O'Keefe's arm. Wing is expected to testify that the wounds are consistent with the injuries from a dog bite. Brennan's argued that Mr. Wing has no experience in pattern recognition analysis or training, and he doesn't believe he's ever testified in court. Now, Brennan asked for a hearing that would allow the attorneys to question the Mr. Wing without the jurors being present. Then Robert Alessi, one of Reed's attorneys, called Wing one of, if not the country's leading expert in training law enforcement in handling canines. He said Wing has extensive experience with wound recognition. The judge didn't rule on that motion. So obviously this guy has some training and experience that probably gets him over the threshold of being an expert under 702. It's not a hard threshold to get over. The fact that he's never been qualified as an expert before doesn't necessarily mean that he's not qualified. Everyone's got to have the first time as an expert. So I wouldn't worry about that. And if the prosecution has a problem with his qualifications and his experience and expertise, do it during, voir dire of him when he's being qualified as a witness, this Mr. Wing, or attack him on cross-examination. That's the way it's done. But for the most part, expert witness testimony is coming in. I'd be very surprised if the judge kept that out. Anyway, like I said, the trial will begin next Tuesday. We'll bring it to you gavel to gavel. Obviously, she is charged with second-degree murder, manslaughter while operating under the influence of alcohol and leaving the scene of a personal injury and death. Obviously, Ms. Reed has entered a plea of not guilty and entitled to the presumption of innocence, which we are definitely going to give to her. And the only final development was the big motion filed the other day that the prosecution plans to use Reed's own words against her at trial, something they've previously stated that they were going to do, and they want to do it in opening statements. Prosecutors are planning to play Reed's various media interviews that she has conducted in the most recent months. Reed said outside of court that Jackson will be responsible for the defense's opening statement. During Reed's first trial, attorney David Udeni handled those duties. So apparently she's putting all her eggs in one basket on the Alan Jackson opening and closing. But this is going to be interesting, right? I am of the mindset that if your client is still pending trial, she has Fifth Amendment issues, she should keep her mouth shut. That includes not going to talk to the press. Now, I know, sounds like Karen Reed is the one running this trial defense. She's running the trial defense here. And so I think she's the one that said, let's go talk to the press. It'll be a good idea. Well, anything you say can and will be used against you. And it's going to. It's always the defendant's own words that get them. Frankly, I'm a little surprised. And I'm sure there'll be a malpractice claim at some point if she loses against her attorneys for letting her go through with such crappy advice. Mark my words. Next, Lori Vallow. That's right. Lori Vallow, the trial that started April 7th, continues on in the trial of conspiracy to commit first-degree murder back in 2019 regarding the death of her fourth husband, Charles Vallow, who was shot by her now-deceased brother, Alex Cox. And what's really making it interesting is, well, Ms. Vallow is representing herself, claiming self-defense, while the prosecution argues that the killing was planned, a conspiracy motivated by financial gain and extreme religious beliefs. So, quick recap of what took place here over the last couple of days. All right. First, we had the testimony of Dr. Derek Baumgartner. He performed Charles Vallow's autopsy, confirming 2 gunshot wounds, one through the heart. Noted Charles could have moved or spoken briefly after the first shot, suggesting the second shot was deliberate, perhaps after deliberation, dare I say. And obviously that supports the prosecution's claim that this was a planned murder, challenging self-defense. Then we had Detective Sandra Yinklin from the Chandler Police Department. The good detective described how Vallow was chipper and unemotional after the shooting, noting that she had chances to de-escalate by returning Charles' phone. Anyway, cross-examination by Ms. Vallow, who questioned the detective, observed a lack of psychological credentials. On cross-examination, Lori Vallow noted that the detective lacked psychology credentials. But yes, you can use your common sense and say, how are they acting? Let the jury, people act differently when bad things happen. Some people get upset, some people freeze, some people get quite emotional, others do nothing. That's a question of fact for the jury to decide. Was that, some sort of this calm demeanor, a suggestion of premeditation? Only the jury will let us know. Then we had Detective Werther from the Chandler Police Department presented cell phone GPS data showing that Lori Vallow was at the Burger King in Walgreens 40 minutes before the 911 call, indicating a delayed report. Obviously, that suggests the staging of the crime scene, supporting the conspiracy claims. Then we had Special Agent Mark Sari, S-A-A-R-I, from the Social Security Administration, and he confirmed that Ms. Vallow received $4,000 a month in survivor benefits post-shooting. Cross-examinations, well, there was lots of objections because it was getting into hearsay. Significance of that testimony reinforced the financial motives of the killing. Then we had Jeff Moberg, firearms expert, tested the gun used, explaining bullet casings, placements, etc. The Lori Vallow cross-examination explored casing variability, right? No one can say exactly where a round is going to go because when it is ejected from the firearm, it depends on how it lands on the ground and whether it bounces in the surface, and you can't really say exactly where it is. You can just say, this is where it is. And unless you were there and you say it didn't get kicked or bumped or moved, picked up, whatever, all you can say is, that's just where it is. There you go. Next, the Delphi homicide case. Obviously, Richard Allen, been convicted, going to spend the next 130 years in prison. And I don't know. I just don't feel sorry. All right. Anyway, slowly, the evidence in the case is being released. And what we did have is video of his interview with the police. And I frankly hate to say it, but, if you talk to the police, you deserve to be convicted. You are probably convicting yourself. And he talked, and he had no good answers to anything. All right. And that befuddlement that he had, guess what? It gets played to the jury, and he looks like a fool, and he looked like a liar. And here's the significant part about it. When you watch the video at the beginning, they'd say, hey, Mr. Allen, we'd like to talk, but understand, you're not under arrest. You're free to go at any time you want. And then on top of that, they say, this is just a formality, but we're going to advise you of your Miranda rights. And they go through them, right? Now, remember, the police only have to advise you of your Miranda rights if you're in custody and you're being questioned about a specific incident, a crime, right? He could have got up and free to go. And if they tell you that, but they advise you of your Miranda rights, they're doing the old belt and suspenders approach to make sure there's no issue on the Miranda advisement to show that it was voluntary, right? Ladies and gentlemen, the Miranda advisement was completely made up. The United States Supreme Court made it up in, I think, 1968 in Arizona v. Miranda. And basically what the Supreme Court said, and I'm reading between the lines here, but they literally said, defendants, we know you're stupid. We know you're scared at this particular moment. And we know that anything you say will be used against you because, we're the United States Supreme Court and we're attorneys and we know that. And any attorney worth their salt is going to tell you to shut your mouth. Never talk to the police, particularly if you are the target, you are the suspect. It is malpractice to do so. Anyway, so the Supreme Court said, what we're going to do is we're going to make a couple of rules for the police. And we're going to say, if you're in custody and they come to question you, they got to give you your Miranda advisements. Anything you say can and will be used against you. Not just what you scribble down on this paper, not just what you write. That's what a lot of people have thought. Well, I only talked to the detectives 45 minutes, but I just wanted to find out what was going on. I had no idea. Well, you put yourself at the crime scene. You placed yourself there with a particular person who's, involved. I mean, just stupid, right? Anything you say can will be used against you. You're entitled to an attorney. If you can't afford one, we'll get you one. Okay? And all you have to do is say the magic word. I firmly believe say it 3 times, like the greatest clip ever made to say when you want a lawyer, right? Slip that in here, Frank.
You, get up. Yeah, you.
All right, lawyer. Lawyer. Lawyer.
There you go. Lawyer, lawyer, lawyer. That's what you do. The police then have to stop questioning you, and they cannot come back and reapproach you unless you have an attorney. Or you say, you know what? I was just joking. Let's talk, right? So when somebody gets convicted, by their own words, ladies and gentlemen, I sometimes have very little sympathy for Mr. Allen. I really thought that was going to be a much more suspenseful case, but then we got phone calls of him saying, I did it. Then we got him, just looking like a fool. But if he had kept his mouth shut, even if he was charged, he would have got the discovery. They could have come up with explanations, but they didn't. They didn't even need to advise him, and he still talked. I'm telling you, ladies and gentlemen, stupid, stupid, stupid. Keep your mouth shut. Next, Luigi Mangoine. That's right. Luigi the Hunk Mangoine is accused of assassinating the United States healthcare CEO Brian Thompson. He's got court again this Friday. Now, Mangoine has become the anti-corporate icon among many Americans frustrated with the healthcare system. His court appearance have drawn, obviously, lots of fans and supporters that want to support the accused assassin and hoping to catch a glimpse of him. But don't worry, you can always give him money. And in this particular case, they've raised almost $1 million. They're up to $900,000 for his legal defense fund. And I think about $1 million ought to cover it to do a death penalty case. Don't know what to tell you. We'll see what happens on Friday. Hopefully, the feds have finally got their act together. They've indicted him and we can get this thing rolling along. It's not a complicated case. It's on video, for goodness sakes. He was captured with the gun, IDs, fake IDs, along with his little, dare I say, manifesto, but his confession, let's just call it what it was, his confession, and saying that I did it, there was nobody else involved, don't want you guys to work too hard. Okay? That's not a defense, ladies and gentlemen. Mitigation at best at sentencing. Let's go try this thing, man. Let's go try this thing. It's not that complicated. Let's get it resolved. Now I'm going to say, if they go death, guess what? It'll probably be delayed a year because they're going to do a bunch of mitigation saying, oh, he came from this, wealthy family and he just had it too easy. He didn't understand the hardships. But when he did start to understand how tough the world was, he became a champion for the little guy, right? The people who can't afford health insurance, can't afford to go to the doctor. So he did the rational thing that everybody would go and do, right? Stalk, hunt down, and assassinate somebody by shooting them in the back. Yeah, I don't think that's exactly the way things are supposed to go. No. Now, we'll give Mr. Luigi Mangoine the presumption of innocence on all 3 of his cases. This murder case in the state case in New York, the murder case and terrorism in the federal court, and then his fake ID case there in Philadelphia as well, in Pennsylvania. So We'll give him the presumption of innocence. Not a hard case to do. Frankly, let's go try the thing. Come on, Luigi. What are you going to do? Spend the $900,000 on commissary? Let's go for it. Next, don't worry. Karmelo Anthony is home safe. I know you were worried when he got released on bond yesterday. Anyway, now Karmelo Anthony has a spokesperson. I wonder if he's a paid spokesperson. I don't know. I think he's like a pastor or something. But the spokesperson for the Texas teenager, Karmelo Anthony, who stabbed another boy at a track meet, has suggested that Mr. Anthony is the victim in this entire situation. But like I said, don't worry. Karmelo Anthony is home safe at his new home. And this moment is a reminder that the community united can never be divided, said his spokesperson / minister, Dominique Alexander, who works with the Next Generation Action Network. Anyway, the journey ahead is long, but today we celebrate a victory for justice, for family, and for the power of the people coming together to protect our youth. Thank you to everyone who stood with him. The fight continues, but tonight, Karmelo is home, he said. Anyway, the activist also shared an image with Mr. Karmelo Anthony, not the basketball player, the stabber, from the teen's $800,000 family home in Frisco. And don't forget they threw in the hashtag Justice for Karmelo and People Power. Anyway, Anthony, he walked out from jail yesterday afternoon after a controversial decision by a judge to lower his bond for charges after he stabbed and killed Austin Metcalf, who died in the arms of his own twin brother. And Mr. Anthony admitted to the killing, according to the police, but Mr. Karmelo Anthony's lawyer has indicated he will claim that he acted in self-defense. Anyway, if you would like to donate, you can. There's a donation page for him where his legal team has received more than $400,000 as of this morning. And many of the donors claiming on their notes when they donate the money that he is the victim in this particular case. Now, the police say that there was a confrontation between Metcalf and Anthony. It broke out during a high school track meet when Metcalf called out Anthony, who didn't attend the same school as Metcalf, for sitting under the team's tent. Metcalf demanded Anthony leave, and the argument escalated when Anthony produced a knife and stabbed Metcalf in the chest, in the heart. Needless to say, he's dead. And the judge, who reduced Mr. Anthony's bond, has gone private on social media after receiving attacks about her ruling, with several social media accounts sharing her image and information as they slam the judge's decision to reduce the bond. Completely inappropriate, everybody. You can say this is the judge, but you don't need to give out her contact information, her housing information. That's called doxing. Inappropriate. No matter how bad you do not like the decision, you don't do that. Anyway, during the hearing, the judge, Miss Angela Tucker, said they've never had security issues they've faced with this particular case. Okay. But the prosecution, when they were making their arguments, questioned Anthony's father, Andrew, about the donation page for him that is approaching the $500,000 mark. Andrew Anthony said that the fund was to be used for Anthony's legal defense. But he also disclosed that the cash would be used for security and to help the family move after the threats that they've also been receiving. The attorney, a guy by the name of Michael Howard, who's been retained for Mr. Anthony, said regarding the money, it would be disingenuous to say there isn't money, but it's not a bond fund. It's the attorney fund. Anyway, and the family also needs money to survive. I don't know if it's going to be used for legal defense. I don't think your legal grocery bill counts for that. I think that's a little bit of a misrepresentation as to how the money is going to be used, but that's just me. And the attorney went on to note, and I agree, every Texan has a right to defend themselves when they reasonably fear for their life. Self-defense is a protection that applies to each and every one of us, the attorney said, and there's going to be two sides to the story. However, the attorney did say he is not ready to disclose why Mr. Anthony brought a knife to the track meet. And we'll give Mr. Anthony the presumption of innocence, but it's an affirmative defense. A defense of self-defense is an affirmative defense. It's saying, I did it. I killed that person, but I was legally justified under the law to do it. We'll give him the presumption of innocence, though. Anyway, as part of the conditions of his release, Mr. Anthony is under house arrest and must wear an ankle monitor. And he has to stay home in Frisco, located on Mercedes Lane, that his family is renting for roughly $3,500 a month. It's a $900,000 house that's renting for $3,500 a month for security reasons. You know, a legal defense area in which to huddle around, I guess. I don't know. Maybe that cynical, suspicious one that I am these days thinks this is a grift. Legal defense should go to the attorneys. Nothing else. Not paid spokespersons, not cars, not meals, not houses. Legal defense. That's it. Let me know if you disagree with me. Next, this day in legal history. In 1866, Congress overrides President Andrew Johnson's veto of the Civil Rights Act. This was the first major law passed over a presidential veto, granting citizenship rights to all free men. Then in 1889, on April 16th, the Oklahoma land rush begins, leading to legal disputes over land claims, and the Indians' rights and obviously helped shape the property law in the West. Don't get offended, ladies and gentlemen. I have done cases in federal court because the cases were being prosecuted on Indian land, and the people were there that were Indians. And they were very proud of the term Indians. Okay. So don't say, oh my God, Scott, they're supposed to be Native American. I asked my client point blank, are you Native American or are you Indian? He goes, I'm an Indian. Don't get all upset with me. All right. On this date in 1933, prohibition enforcement peaks with federal raids on illegal distilleries in Chicago, highlighting organized crime's grip during the era. Then in 1943, United States Supreme Court hears the State Board of Education versus Barnett, later ruling against mandatory flag salutes, a landmark First Amendment case. Then in 1970, the Organized Crime Control Act, including RICO, is proposed, later revolutionizing prosecution of the mafia and white-collar crime. And then also on this date, in 1963, an incarcerated Martin Luther King Jr., arrested for demonstrating in defiance of a court order, wrote his famous letter from the Birmingham jail in response to a published statement by 8 fellow clergymen from Alabama. Part of the letter reads as follows, and I will use the exact language that is in here, except for one, and we'll go from there. So the letter from Martin Luther King from an Alabama jail. We have waited for more than 340 years for our constitutional and God-given rights. The nations of Asia and Africa are moving jet-like speed towards gaining political independence, but we stiff creep at horse and buggy pace toward gaining a cup of coffee at a lunch counter. Perhaps it is easy for those who have never felt the stinging dark of segregation to say wait, but when you have seen vicious mobs lynch your mothers and fathers at will and drown your sisters and brothers at a whim, when you have seen hate-filled policemen curse, kick, and even kill your black brothers and sisters, when you have seen the vast majority of your 20 million Negro brothers smothering in an airtight cage of poverty in the midst of an affluent society, when you suddenly find your tongue twisted and your speech stammering as you seek to explain to your 6-year-old daughter why she can't go to a public amusement park that has just been advertised on television, and see tears welling up in her eyes when she is told that the fun town is closed to colored children, and see ominous clouds of inferiority beginning to form in her little mental sky, and see her beginning to distort her personality by developing an unconscious bitterness towards white people, when you have to concoct an answer for a 5-year-old son who is asking, Daddy, why do white people treat colored people so mean? When you take a cross-country drive and find it necessary to sleep right after the night in an uncomfortable corner of your automobile because no motel will accept you? When you are humiliated day in and day out by nagging signs reading white and colored, and when your first name becomes the N-word, or your middle name becomes boy, however old you are, and your last name becomes John, and your wife and your mother never given respected titles like Mrs., when you are hired by day and haunted by night by the fact that you are a Negro, living constantly at tiptoe stance, never quite knowing what to expect next, and are plagued with inner fears and outer resentments, when you are forever fighting a degenerating sense of nobodiness, then you will understand why we find it difficult to wait. There comes a time when the cup of endurance runs over and men are no longer willing to be plunged into the abyss of despair. I hope, sirs, you can understand our legitimate and unavoidable impatience. Powerful stuff. And then finally, our dumb criminal of the day. An employee at Royal Farms called police to report that an unknown woman had come in the previous day and defecated in the beer cave. Now, in the affidavit for the arrest warrant, it describes the beer cave as a walk-in cooler open to the public to select cooled beverages. All the doors into the beer cave and coolers are, there's a glass area providing a visual of the inside for the common area of the store. The police reviewed the security footage and it showed the suspect pushing a case of beverages back on the shelf, pulling her pants down and defecating on the shelves, and then left. Cameras recorded the woman arriving at the Royal Farms in an SUV. The vehicle registered to a Crystal Goss as the individual driving the car when the offense occurred. A driver's license photo of Goss matched the suspect depicted in the surveillance video, the police say. And Goss was arrested for several crimes, including open lewdness, criminal mischief, and disorderly conduct that created a hazardous and physically offensive condition. According to the complaint, which does not indicate why Goss allegedly used the beer cave as a toilet, caused about $80 worth of damage. Goss apparently lives about a mile from the Royal Farms store and is the director of food and nutrition for the local school district. Miss Goss, you are a dumb criminal of the day. Hey, maybe, I don't know, maybe she just had one of those moments like, oh my God, oh, this is terrible. The stomach, right? Everyone's been there. But you find a restroom, for God's sakes. You don't go to the beer cave and take a big dump. Come on, Miss Goss. That's gross. And you are a dumb criminal of the day. All right. Hope you enjoyed the show. Have a wonderful day. We'll see you next time. And remember, the Constitution matters.